Good evening. Am I audible to you?
Yeah.
Yes, yes.
Okay, thank you very much. And we would like to welcome you all for today's event, actually jointly organized by Institution of Engineers Sri Lanka and Association of Consulting Engineers. We will organize a series of this kind of lectures, seminars, starting from today, every month, actually. So without going to detail, actually, I would like to invite our President-elect Engineer Dr. Kamal Laksiri. He is also past President of Association of Consulting Engineers to express few words. Dr. Laksiri, what do you say?
Okay. Thank you. Thank you very much. I hope you all can hear me.
Yeah, we can hear you. Yes.
Okay. Yeah. Good evening to all of you. Our resource person today, Dr. Anandaran Singha, and we have a very good number of members joining, and I'm very happy that Professor Kumaraswamy is also joining us. You are most welcome. And this is an event, as Engineer Hemachandra mentioned, jointly organized by the ISL and the Association of Consulting Engineers, Sri Lanka. Actually, today we are facing a power cut also in some areas. So some members are facing problems in joining, but still we have a good number joining today. And if I just mention the objective of this program, now this is the first episode of the series of lectures or programs we are planning to conduct under the title, Let's Discuss Your Contractual Issues. So we have invited a veteran in the subject, Dr. Anandaran Singh. I think no, you don't need any introductions. You all know him. One of the past presidents of ISL. So he'll be the resource person today. Now, if I just mention the objective of this program, why we decided to conduct this type of programs. Now, we find that of course, to enhance the knowledge on contract management in our of our members. Now, we find that I would say there's a members' knowledge in the in contract management needs to be improved, and as ISL, we consider it as our responsibility. And then we have the Association of Consulting Engineers, that is the national arm of the national chapter of the FIDIC International. So they are also handling this. So we thought to connect them and to do this so that our members will get a good opportunity. Now, if you look at, we can see in the practice many problems with contract claims, contractual issues. So there we can find that we do sometimes very primary mistakes due to lack of knowledge. And for example, if you are in a major project, now in major projects, most of the time you have to use the FIDIC documents or the documents specified by the lending agencies, either ADB or JICA. So in these projects also, I have seen in many occasions, either we use the wrong book, and in case of, if you look at the FIDIC, we have a number of books on measure and pay book, red book, yellow book, green book, gold book, many silver book, but sometimes these books have been established with a particular purpose, very clearly defined, but still we use the wrong book. Sometimes I don't know who decides, but somehow it happened, and then finally you face a lot of problems. And the other thing, what I have noted, this is not a problem in this country, it is happening in many countries. So once I attended a program in Indonesia in a contract management program. So they were discussing it as a serious problem in using EPC in their country. So EPC, now you all can see in many projects, we simply use EPC. But if you go to EPC preface, it's very clearly says not to be used in contracts involving major portion of civil works, major percentage of civil works. So, but still we used it in underground works also and many civil contracts. So this type of things happening because of the lack of knowledge on contract this application. So one idea of this program is to enhance your knowledge through actual practical cases, case studies, and so we will plan this program and continue the other, and also to learn about the other concepts like dispute boards, adjudication, arbitration. So that will be, as engineers, we need to learn about all this if you are to practice as a practicing in the project management field. The other aspect I want to mention is that as engineers, we are also experiencing another issue in the field, that due to our backwardness or our lack of knowledge, various other disciplines are also trying to engage in this contract management and project management. Maybe some of you have experience already. Now, in the past, when in a major project, we always had a contract engineer or contract manager. He is the one who decides on the contract affairs issues. But unfortunately, nowadays, non-engineers are trying to engage in this first and causing a problem. It is happening already. So this is one thing we need to address as engineers. We need to, this is our subject area, we need to be thorough with that and do our part. So as ISL, we are planning this type of lectures, and also we are planning to conduct on programs on FIDIC modules along with the Consulting Engineers Sri Lanka, Association of Consulting Engineers Sri Lanka, and I'm sure it will be, you will find it interesting and useful. So this today for the this initial program, the opening program, I'm again thank Dr. Anand Ranasinghe for agreeing and accepting to join us, and he will continue to attend with us. And with that, let me conclude my brief introduction. I thank you all again for joining today, and I am very sure you will find this a very interesting program. And also I would like to thank the engineer Hemchandra, the chairman of the Policy Forum, for organizing this, along with the president of Association of Consulting Engineers, Engineer Anurag Gamage. Thank you very much. Thank you.
Thank you very much, Dr. Kamal Laksiri, for your descriptive speech. Actually, we want, for the formality, we want to introduce Engineer Anand Ranasinghe, but he kindly requests us to not to waste time, because power cut and all, he want to start immediately. Therefore, I would like to invite Dr. Ranasinghe to start with his proceedings. Thank you, sir.
Thank you very much. I think I am very grateful to Dr. Kamal Laksiri for encouraging these type of programs in order to enhance the knowledge of the contract law and contract law among the engineers. I am also thankful to Mr. Engineer Hemchandra for the effort he has taken to organize this event in spite of power cuts all over the places. In fact, I am also running on a generator at the moment, so I hope I have diesel at least 1 hour. So let me start the discussion initially. Now, in every field, actually, unlike engineering and various other fields, you have to have a fair knowledge of the basic principles of contracts law in order for you to administer a contract. It is the audio level is all right, Engineer Chandra, or you have to be louder?
I think, yeah, for me it's perfect. I think other members also, I think will be okay. Yeah.
Can hear Hemchandra. Sir, we can hear you clearly.
Okay. Now, basically what I'm telling is actually now in engineering, when we study engineering, we study laws of gravity, etc., which will be beneficial in order for us to tackle complicated problems. Now, even in law, there are areas that we have to cover in order for us to administer contracts at a different level. So therefore, I will just, as a brief introduction, I will tell what are the basic principles of law for you to, in order for you to familiarize it, although some of the some of the participants are very senior members in the profession. Professor Mohan Kumar Assam is my best mate, and he's also participating, as the chairman said. Now, in order to form a contract, basically there should be, before that, I want to say something about our legal system. Now, we don't have a document for sale of goods, etc. That is for movable property. We have an act called Sale of Goods Act. Now, for construction contracts, we don't have a proper contract law in this country. So therefore, nobody has taken interest to pass a contract law. Now, in other countries, in India, there is a law of contract which has been passed by the parliament. So therefore, our common law, we are using our common law in order to administer contracts in Sri Lanka. Our common law, probably most of you must be aware that our common law is Roman Dutch law. Because when the Dutch came to Sri Lanka, they introduced a legal system to this country. But after the Portuguese were invaded by Dutch, they introduced what is called Roman Dutch law, which is the law at that time prevailed in Netherlands. Now, Roman Dutch law background is very important for us to understand our legal system also, because that is the law which is prevailing in this country. Now, when you enter into a contract, you have to be very mindful that you have a background. Whether you have written or unwritten law, you have a background of common law in this country. So, if A and B enters into a contract, the basic principles governed by A and B are Roman Dutch law or the common law of this country. But on top of that, actually, you can have any conditions of contract between the parties. So in order to complete your contract between other parties. So your basic law, the background law is called common law. And on top of that, you have conditions of contract, sale of goods, etc. In fact, a famous legal writer, Professor Nadraja, I think, he has mentioned that our legal system is like a dilapidated thatched roof house, where we had the Roman Dutch law prevailing in this country, but with over a period of time, Roman Dutch law has perished, gone to abeyance, and it has been taken over by the various English legal principles. So therefore, don't get confused. Although we have a Roman Dutch law background, we use the English judgments in order to explain or in order to clarify the Roman Dutch law principles. So most of the judicial precedences, that is judge-made law, we adapt English law principles. So coming back to the subject matter, now in order to form a contract, there should be an offer and acceptance. That's very important. Now the offer has to be made normally in our construction contracts. Actually, I will do a comparison. In construction contracts, the offer is made by the tenderer, who is going to be the finally a contractor if the employer agrees it. So therefore, offer is made by the tenderer or eventually the contractor, and acceptance has to be made by the employer. So these are tied together. Now, the law, there had been a lot of problems in the past in law, where sometimes they want to differentiate offer and invitation to offer. Because there had been instances where the people were not very clear what is invitation to offer and what is offer in a contract. So therefore, there were cases where people said that when there is an offer and when there is an acceptance, a contract will be formed. But sometimes they say, no, it is not an offer, it is an invitation to offer. So therefore, there are various cases that has been decided in the past. There is a case called Fisher versus Bell. And in that case, what has happened is there was in a shop window, there was a display of knives, which has to be sold only for people, those who have license to buy those knives, probably elderly people. So when these knives were on the shop of a window, the legal authority or the enforcement authority of that country filed actions against the supermarket, saying that you are selling articles which are prohibited to sell in an open market. So this went to a court in England, and they said the items which are displaced in a shop window is not an offer, it is an invitation to offer. So the offer has to be made by the customer, then acceptance have to be made by the people, those who are selling this one, that is at the counter. So therefore they have not done any offense, because the items they have not offered for sale. They have said these displaying items are invitation to trade. Similarly, there have been several other cases like Pharmaceutical Society versus Boots also. This is a similar case. Now, why I am explaining these cases, actually, you can get a copy of these cases in the internet. Now, everything is available in the internet. So you have to know at least a brief story of the case, so that you know why we treat this in such a manner, so that you can get an understanding. So case law is very important in countries where the common law is adopted, like Sri Lanka, England, UK, Australia, etc. Now, in pharmaceutical versus boots, what happened was, whatever happened was, actually, there were prescribed drugs in a counter of a shop in a supermarket. So therefore, the authorities, the law enforcement authorities of that country, they filed action against the supermarket, saying that you are displaying drugs which needs a prescription from a doctor, and therefore you are making an offer for the customers, and as a result you are violating the terms of the pharmaceutical act, or whatever the act you are violating. But even in that case, it was decided that display of items in the supermarket is not an invitation, not an offer, it is an invitation to offer. The actual offer is made by the customer, and the person who is at the reception or at the counter, they can always refuse your offer. So therefore, they said there is no offer made by the supermarket. It is only an invitation to offer. So therefore, these concepts, invitation to offer and accept, is very important. Now, if we relate this to the construction industry, when you call tenders by a newspaper advertisements, these are called invitation to offers. They are not offers. So therefore, even if it is an offer, the first person you have to give your contract to the first person who accepts that offer. But in this case, since it is been invitation to offer, whenever tender documents are collected by the contractors or the tenderers, when they submit that to the employer, that is treated as an offer. So employer has an option of selecting who he prefers to give the contract. So the contract will be taken place between the tenderer and the employer. Tenderer makes an offer and the employer makes an acceptance. So these two should be there in order for the parties to form a contract. Now it has been said that it is like formation of a contract is like matching fire, setting fire to a gun explosive filled with explosives. You can't reverse it back. If you want to reverse it back, you have to pay compensation for the affected party. So once the offer and acceptance are made by the parties, contract will be formed. So I will give you two good examples which I have experienced, and I have consulted on this matter, and only from this principle I was able to convince the other party to convince the tribunal in order to give a decision in my favor. Now, in one of the cases, actually, this person, the contractor, he had made an offer to construct a petrol station in somewhere around Anuradhapura, I think. And he has mobilized himself in order to construct this petrol station. So when he went to the site, he was shown the boundaries and he started clearing the area. Now the person who was next to a neighbor, when he started clearing this one after mobilization, he came to the site and said, "This is not the property of Petroleum Corporation. This is my own property, so therefore I am not allowing you to proceed with construction." ultimately they have found that it is true because these people have started construction on somebody else's land. Now he has not signed the contract with the corporation, but he has been sent, he has received a letter of acceptance from the corporation. That's the only document that he has had in his hand in order for him to say that he has signed the contract. Now the tribunal, it went to arbitration, and the arbitration tribunal held that when you send a letter of acceptance to the tenderer, a contract will be formed. So you don't have to have a written contract between the contractor and the employer. Once the offer made by the contractor is deemed to have been accepted when the employer sends a letter of acceptance. So therefore, employer was liable to pay compensation for mobilization of the contractor, although that contract was not performed by the contractor because of this issue. So therefore, this has been only by applying basic principles of contract law. So therefore, we have to remember it's a very important things. In order to form a contract, there should be an invitation to offer and acceptance. Now, there was another case which was referred to me by a contractor where he has undertaken to do a multi-story building. I think it must be a condominium property. I don't want to disclose that one. And where he has taken an advance payment of 100 million rupees in order to start the work. Now, when the contractor went through the documents, he has found that he will not be able to complete the work within 2.5 years. It's a fairly tall building. And the penalty is 1.5 million per day as delay damages. So therefore, he doesn't want to continue with the contract, although he has taken an advance payment. So when I was consulted, I went through the documents and I found that there had been an advance payment and say, in order to form a binding contract between you and the employer, the contract has to sign an agreement. So unless the parties sign an agreement, they have said there is no binding contract between the parties. Now, fortunately for this contractor, although he has taken an advance payment and he has even started work, he has not signed the contract. So therefore, I told the contractor, I drafted a letter to the contractor and said, you send this letter to the employer and said, I am withdrawing my offer. I am not prepared to continue with the contract. I am withdrawing my offer. Now, when this letter was received by the employer, he found that he has done a serious mistake by having this clause without signing the contract. He has made an advance payment to the contractor as well. So therefore, he couldn't hold to the conditions which he has been laid down in the contract of the liquidated damages that he wants to impose on the contract. Now, as a result, what the employer said was he was prepared to negotiate this matter with the contractor, and therefore the contract period, instead of having 2.5 months, it was extended by another 1 year or so that the contractor can, without any causing delays, could complete the contract construction work. So therefore, why I said these two examples are because basic principles are very important when you are administering a contract. So if you know the basic principles of contract law, which if the President-elect permits, we can have a separate item on the contract law, so that if you know the basic principles, actually you are, I would say, better off managing the contracts than just making a trial and error on the contracts. Now, the other important aspects of the contract in order to form a contract is offer and acceptance is not sufficient according to the Sri Lankan law and also according to the British law. There should be something called consideration. I think there is 4 messages. Shall I go through it quickly? Now this is about, yes, send a message about muting mics. Okay. So other thing is actually there should be consideration in order to form a contract. Now, consideration according to the English law is actually there should be some value transfer from one party to another party. Now, it has been decided in cases in England that consideration need not be equal to the amount of work or amount of goods that you are going to buy. The court will not go into the valuation of the goods or valuation of the contract and say this consideration is insufficient or its consideration is sufficient. Consideration means something must be transferred from one party to another in order for the other party to perform the contract. Let's say if I want to buy 100 mangoes from a seller, if the seller says I'm charging only 1 rupee for my mango or 1 rupee for 100 mangoes, that is good enough consideration because that is a bargain which has been communicated between the employer and the contractor. So if I bargain for 1 rupee for 100 mangoes, he can't deny selling the mangoes because consideration need not be equal to the actual value of the goods. So that is also very important under the English law. Now, our contracts actually, as I said, construction contracts are basically governed by the Roman Dutch law principles, in addition to the conditions of contract which you have entered into with the other party. So our consideration in Sri Lankan law is slightly different from the English contract law principles. Now, I will give you another decided case on this matter. It's called Rahman versus Public Trustee. What happened in this case was that a person, when he was at the dying bed, when he was about to die, he promised his faithful servant that I will give you some amount of rupees, maybe about 30,000 or 40,000 rupees to you for the good service that you have performed me in addition to the salaries that I have paid to you. So this is in addition to the salaries that he has been paid by the employer to this servant. He promised that he will pay you 30,000 and it will be paid by my son or daughter, so that because they have assets, my assets with them. Now, when the person died, the son or the daughter refused to pay this amount because he said, in order to pay an additional consideration, there should be additional services from the servant, whereas servant has been paid his salary right throughout. He has been compensated for whatever the work he has been done. But the court held otherwise. Court held consideration applicable to Sri Lankan law in this instance is not the English law principles. Now, Roman Dutch law says that supposing if you make a serious promise to another person, that is good as consideration. So therefore, it was held that the daughter or the son-in-law is liable to pay the amount agreed by his father-in-law, because Roman Dutch law principles applies to the normal contracts. Now, we have to be very careful. Actually, now the Roman Dutch law applies to general contracts. But there are various contracts which are governed by the English law principles also in our country. Now, for example, sale of goods are governed by English law principles. Then insurance contracts are governed by English law principles. So therefore, consideration in those cases might be differ from the Roman Dutch law principles, which I have explained to you. Now, up to now, is there anything that you would like to clarify, or rather than continuing right forward, is there anything that you would like to clarify? Two gentlemen have sent me questions, which I will discuss later once I finish the basic principles. Okay, I will proceed then. Now, sometimes in contracts, actually, there are what are called express terms and implied terms in a contract. Now, this is also a very important concept, because now when you, in normal contracts, actually, as explained by Dr. Kamal Laksiri, we have using various types of documents. So therefore, whatever written in those documents are express terms in the contract, because parties have signed this document by agreeing to these documents. Now, there are certain implied terms in the contracts as well. Now, for example, if you go and buy a shirt from a shop, from a supermarket, there is an implied term that you should be able to wear the shirt. You have to have two sleeves on both sides. You can't have a sleeveless sleeve, one sleeve on one side without a sleeve on the other side. So there is a called implied terms in contracts. You don't have to lay down each and every clause in the contract under normal contracts, in sale of goods contracts, etc. But in construction contracts, normally we have a habit of having most of the conditions laid down. These are called express terms of the contract because parties have agreed to these terms. So shall we get on to the real document, which is called the FIDIC conditions of contract? Now I will come to the principles of contract law whenever when we need to discuss those things. But I will quickly go back to the FIDIC conditions of contract, so that if there is any principle on the contract law, we will discuss. Now, basically in the conditions of contract in FIDIC and also from CEDA conditions of contract, there is what is called definition clauses in the initial chapter, initial chapter 1, there are called definitions. Now, in any document, for example, in an act or in the conditions of contract, when you have definitions in a contract, the term which is given in their defined term in the contract, the interpretation will be the defined term at a later stages. For example, it says letter of acceptance, and letter of acceptance is defined under the definitions. So whenever letter of acceptance is referred to in a document at a later stage in the contract, the defined term will take the precedence. So therefore, definitions are very important in the conditions of contract because that is the governing term in the contract, conditions of contract. Now, basically, I think CEDA conditions of contract as well as the FIDIC conditions of contract, they have used similar definitions right throughout the contract. But there are a few modifications which I will discuss with you, the repercussions of these modifications, because these modifications, if you are doing, you have to be very mindful of these modifications. If I give you one example of these modifications which has been done by CEDA. Now, in the FIDIC conditions of contract, unforeseeable is defined as, I will read that portion. Unforeseeable means not reasonably foreseeable by an experienced contractor by the date of submission of the tender. So unforeseeable, if it is unforeseeable in a contract, normally contractor has a claim. So normally, let's say there's unforeseeable ground conditions and the contractor never anticipated that these type of ground conditions will prevail. There are rocks and concrete blocks, etc. Then it's a compensation even for the contractor because he was not aware of these conditions at the time of entering in the contract. So therefore, they have said at the time of by the contractor by the date of submission of the tender. That means he has not even gone to the grounds. Unforeseeable means actually when he submits his tender, he may have done a site visit, etc. But he has not even seen what is happening, what is inside the ground, what is the access problems and various things. So unforeseeable means at the time of submission of the tender. Now the ICTAD conditions of contract, they have changed to this one and say, unforeseeable means not reasonably foreseen by an experienced contractor. Now they have dropped the portion of at the time of submission of the contract. So therefore, this has made, read these two very carefully, this has made the contractor very vulnerable because he can't claim something at a later time because unforeseeable, there is no time taken has been taken by the CEDA. So therefore, conditions of contract, if you are going to vary the conditions of contract, sometimes there might be advantages to you, but you have to be very careful because these conditions of contracts have been prepared by knowledgeable people. So you have to double check when you are making any changes to these conditions of contract. Now I think Dr. Laksiri talks about this engineer definition also. I will read this engineer definition. We have very little time, so before I will finish the definitions and we will go back to the main discussing problems. Now, engineer means, according to the FIDIC conditions of contract, engineer means a person appointed by the employer to act as the engineer for the purpose of the contract and name in the appendix to the tender. So, engineer is basically FIDIC conditions of contract. They have said engineer means a person appointed by the employer to act as the engineer. There is some emphasis to the engineer saying that he should act as the engineer. Now, the engineer definition which is given in the new FIDIC conditions of contract is completely different. I will read the engineer definition in the new FIDIC conditions of contract. The engineer, or if the legal entity, the natural person appointed to act as its behalf of, shall be a professional engineer having suitable qualifications. A professional engineer having suitable qualifications, experience and competence to act as the engineer under the contract and shall be fluent in the ruling language. So therefore, they have identified the importance of the engineer. So when you are acting as an engineer in a project, there are a lot of people acting as engineers, I know, senior people, those who have attended the lecture today. You have to be very familiar with the conditions of contract because they expect that you are a professional engineer who is administering the contract. So therefore, those are the definitions which I would like to discuss. Now, so we will come back to the definitions if they want anything now. Other thing is actually now materials also there is a slight issue in this one. Now I have observed in one of the contracts which I am also participating, the engineer, the contractor has abandoned the contract. Contractor has, without completing the project, he has abandoned the contract. Now, according to the contract, the engineer has retained the property of the contractor, saying that is already stated in the conditions of contract. But as an engineer, you have to be very mindful. Actually, some of the property is the contractor was carrying a leased equipment hired from various organizations. So the contractor may not be the owner of the equipment. So therefore, you can't retain property which belongs to somebody else. Although you have a contract between the contractor and the employer, you can't hold property which is not the property of the employer. Sometimes there are situations where the contractor brings loads of sand, loads of tiles, etc., without making payments to the seller, that is who is a shop owner. So the property has not been transferred to the contractor. Property still belongs to the shop owner. When you buy something and when you don't pay the money, although you are utilizing that property, you are not the owner because you have not paid the money due to the seller of the property. So in such instances, actually, you can't hold properties of the contractor. Now, Mr. Hemachandra, we have only very little time today. Shall I discuss the problems which has been sent by the gentleman? Or
It's okay, Dr. Anasinghe. Oh, yeah, we can go to the questions, and if you have time, we can even open for few discussion points as well, right?
Okay. Now, I have received two questions. One question from Mr. Engineer S.M. Rafiz. He has sent two questions. Shall we discuss these questions? I will read these ones. Unfortunately, I can't display these questions now at the moment. I have hard copies. First question is after, I will read the question so that the answer will be meaningful. After obtained engineer and relevant authority approval, RDA, During the construction stage, engineer and the RD authority instruct the contractor to do design revision and variation. However, such design revision is essential as per the existing site condition. But now the contractor in a final stage of commissioning and resource allocation and material purchase are much difficult. In this scenario, contractor can be able to avoid that variation instruction due to above mentioned difficulties. I think this is a very important questions I will discuss with respect to the clauses in the FIDIC conditions of contract. Now in the FIDIC conditions of contract, I think clause 12.4 or something. 13.1 and also 13.2 discuss variations and adjustments to the contract. Now, if it is a variation to the contract, it says, I will read this portion from the FIDIC. Variations may be initiated by the engineer at any time prior to issuing the taking over certificate. But only thing is you have to differentiate what is a variation and what is a new work. Now here, according to the question raised by this gentleman, he said there are certain variations which are essential for completion of the project. It says, state engineer RD authority instruct the contractor to design revision and variation. However, such design revision is essential as to existing site conditions. Now supposing if the variation is essential as per existing site conditions, that is part of the contract. If it is a variation with respect to existing site conditions, that could be part of the contract. Now, why I want to emphasize that is that in fact, I was a DAV member in part of the Southern Highway, where we were supervising, we were DAV members from Satarma up to somewhere around Gaul, not Gaul, it doesn't go to the Gaul, somewhere around Gaul. And also Gaul access. Now the main road, that is Kundumagaha Satarma up to the Gaul access, we had a complete specification to complete the roads. But the Gaul access, the contract said only the earthworks up to a certain level, not the sub-base, base, and the what you call bearing surface, etc. Now, engineer has issued a variation saying that this road can be used for people, those who are traveling from Gaul as well. And therefore, he issued a variation in order for the Gaul access to be completed by using sub-base, subgrade, etc. The contractor refused to do that. He said, no, it is not a variation, which is true. Because from a variation, actually, you can't issue instructions in order to do work which is not already incorporated into the contract. Variations, the work that could be incorporated into the contract is very little. But variations might be necessary in order to complete the works. Now, for example, his problem is a typical one. He says revision is essential as per the existing site conditions. Let's say if you have to raise the site by another foot because of the flood levels. Now that is a variation which is essential in order to complete the works. Therefore, contractor cannot ignore a variation which has been issued in order to complete the works as it is. But only thing is actually there are few exceptions given here. And it says variations can be changes to quantities of any item, changes to quality, changes to levels, omission of any work, etc. But there is another clause here saying that the contractor can avoid the variation provided is unable to find the construction materials. If it is not possible to find the construction materials, he could say that he is unable to complete the variation. So therefore, this situation can be tackled provided the employer is also helpful in finding the materials. Because generally he has to do it, but there is an exception given in the FIDIC conditions of contract. I am looking for the clause. Is there anybody who can remember exactly what the subclause is? it says the contractor shall execute and be bound by each variation unless the contractor promptly give notice to the engineer stating with supporting details that the contractor cannot readily obtain the goods required for the variation upon receiving the notice. Therefore, if the contractor is unable to find goods in order to complete the works, contractor can say he is unable to perform the variation. So if it is essential for the works, I think probably the employer should be helpful in finding materials so that he can get the work done. Because there is an exception to this variation if the materials cannot be found. Are you happy with the answer, Mr. Rafiz? I hope he's here in the lecture. Mr. Rafiz, are you happy with the answer? The second question he has raised is that engineer instructed to suspend the work due to certain reason, not acceptable, after the contractor explaining and contractual argument. 40 days later, engineer officially again allowed the contractor to proceed the construction work according to the contractor, continuing the work after 40 days suspension. However, we noticed them at that time, due improper suspension notice, contractor suffered lost profit and idling resources. Almost now 4 months have been passed. Is it possible the contractor to claim idling cost and other costs because the wrong suspension? Now the question is actually the contract engineer has given instructions to the contractor to suspend construction work. Now the contractor suspended the construction work, but now he is making a claim after a long lapse, after 40 days of suspension. Can we sustain that claim after 40 days? So I will answer the chats after answering this question. Now here, once you instruct the engineer to stop construction work, once you request the contractor to stop construction work, the definitely contractor will incur additional cost because he might have to stop construction, his machinery will be idling, then he has overheads cost, office overhead cost, labor cost, etc. So there will be additional cost. So under normal circumstances, you have to pay the cost of the contractor, cost of overheads, and sometimes profit also. Now, overheads and profits are defined separately in the FIDIC conditions of contract. But there is another important clause in the conditions of clause. FIDIC says 20.1, I think it is 19.1. Now there is a clause which is called condition precedent clause. Condition precedence means if the condition has not been fulfilled by the contractor or the person who is claiming, his claim will be vitiated. He can't make a claim from that event because condition precedence clause is a very powerful clause in the contract. Clause 20.1 says, I will read the subparagraph B only for your information. 20.1, I am reading only the subparagraph. If the contractor fails to give notice of a claim within such period of 28 days, the time for completion shall not be extended. The contractor shall not be entitled to additional payment and the employer shall be discharged from all liability in connection with the claim. Otherwise, the following provisions of this subclause is applied. So therefore, it is very clear in the FIDIC conditions of contract. There is what is called condition precedence clause, saying that if you do not make a claim, give notice within 28 days, your entitlements will be, you will lose your entitlements. So if it is not fulfilled by the contractor does not have a claim. But unfortunately or fortunately to the contractor, clause 19.1 in the FIDIC conditions of contract is CEDA conditions of contract. Same clause, they have copied paragraph 1, identical paragraph on FIDIC. Paragraph 2 has been dropped in the CEDA conditions of contract. Paragraph 2 says, 28 days after contractor became aware or should have become aware of the event circumstances. Paragraph 2 is contractor shall submit any other notices, etc. So they have dropped the condition precedence clause. So, gentlemen, if you are using see the conditions of contract without any alterations to the contract, a contractor has a reasonable claim because he is not bound by the conditions precedence. But if you are using the FIDIC conditions of contract, you are bound by the condition precedence, and therefore, contractor has no claim. Shall I go to the, there are few questions raised by gentlemen. There are some short-term contracts, 90 days, which doesn't have price escalation. How to tackle the awarded contract with, so that is not a question, sorry. Question 1 is, the engineer appointed by employer and deployed to monitor the project will be biased to the employer than contractor. How do you comment on that? Engineer to the project should be unbiased, but it will not happen. So normally I think it is, and this question is actually what he says is the gentleman, engineer Ayesh, he has raised a question, saying that engineer is being appointed by the employer, therefore engineer is generally biased because he is being paid by the employer. I think this is a universal problem, which the FIDIC has slightly softened the situation by saying that, I will read that portion also for your information. One 1136. 1136, sorry. 1124. I will read the definition from FIDIC, the engineer's definition. FIDIC is a reasonable definition. It says the engineer means the person appointed by the employer to act as the engineer for the purpose of the contract and name in the appendix to the tender, or other person appointed from time to time by the employer and notified to the contractor under subclause 3.4. So FIDIC says that if you can appoint an engineer at the initial stage, but if you are going to replace the engineer, the contractor has a right to object to the new engineer. Because supposing if you have a reasonable man as the engineer, if the employer wants to change the engineer, he can't do that because the contractor can object to such changes. So therefore, FIDIC gives some concession to the contractor because he could be partial, but you can't. If he's a reasonable man, you can't change according to the whims and fancies of the employer. And unfortunately, CEDA has been very liberal on this one. It says, in the absence, I will read only the last person. In the absence of such appointment, the employer himself, so therefore definitely is biased. I don't think you can do anything about this one unless you adapt the clause given in the FIDIC conditions of contract. And I read the clause in the FIDIC new version also, which is fairly useful to you, I think. FIDIC new version 2017 also similar to the FIDIC old version. Next question is from, is there any clause for the current economic crisis? I think probably with this answer, I might have to close today's session. This force major clause is probably very useful for the current economic crisis, force major clause. So I will explain, can I explain the force major clause in the conditions of contract? It might take a little bit of time. Are you all right? Engineer Hemchandra, can I explain?
Yeah, we can go as this is first event. Maybe later we can make kind of operational rule how we can conduct this event. So please go ahead as you wish. Yeah, please.
Yeah. Now, force major is, now you have to read this clause very carefully. I think clause 19.1 discusses about the force major in the conditions of contract in FIDIC. I think they have changed 19 and 20, interchange 19 and 20. Now, in the FIDIC new version, they have changed this force majeure to exceptional events, but the conditions are identical. Conditions which is laid down in the force majeure are identical. Now, in order to come back to this topic, actually, I have to explain something about frustration in contracts. Generally, in English law, the initial position was that in English law, if you agree to do something, you have to perform it. There is no excuse. Then you can't be excused from not performing. There's a case called Paradine versus Jane, if I can remember right. In that case, actually, it was held, if you promise somebody to do something, you have to perform it. That was the original condition. But later, there was a clause, frustration of contract clause was developed in England, where a cinema hall was gutted by fire, and therefore there was a situation where the owner of the cinema hall could not hire this hall for the person who has booked this hall. So the person has booked this hall in order to have some performance, but he was unable to perform because the cinema hall was completely destroyed by fire. The court held that if it is make it impossible to perform, then probably you don't have to perform a contract. It will be the loss lay where it falls. That means actually either party doesn't have to bear any losses. Whatever the losses they have incurred has to be borne by them because the contract has been frustrated. That is the current law in Sri Lanka as well. If the contract is frustrated, you don't have to perform. Frustration means actually it has made it impossible to perform. But there is another concept called force majeure. Now, initially the concept was actually if you agree to do any contract, until you agree to sign a contract, you have to perform the contract 100%. Then the frustration came. Frustration said if it's impossible, you don't have to perform. Now there is another concept in civil law countries, in European countries called force majeure. Force majeure means actually if there is a difficulty in performing the contract, then you don't have to perform, not impossibility. There is a difficulty in performing the contract. So that is the clause which has been adopted by the FIDIC conditions of contract, which is called force majeure. Since this force majeure is going to confuse with the civil law concept of force majeure, the new conditions of contract, they have introduced what are called exceptional events. The same as force majeure, but in order to avoid confusion of force majeure, they have introduced exceptional events. Now, exceptional event means, I will read this portion. It is very useful because this can be used for COVID situations, which I have addressed this one in my book also. It says in this clause, force majeure means exceptional event or circumstances, which is beyond parties' control. Now, COVID was beyond parties' control, which such party could not reasonably have provided against before entering into the contract. Nobody anticipated that there is going to be a COVID-19, except few astrologers, which having arisen, such party could not reasonably have avoided. So the COVID situation is ideal for this one, which is not substantially attributed to the either party. So all these four conditions have to be satisfied in order for you to claim under force majeure. So I believe that COVID falls into all four categories mentioned here. Now it says that force majeure may include but not limited to the exceptional events or circumstances of the kind listed below, so long as condition A to D above are satisfied. So all these four conditions which I distribute, you can refer to FIDIC conditions of contract. 19.1 A, B, C, D, all those four conditions have to be satisfied. Then they go on to explain the other condition that has to be satisfied with A, B, C, and D. A, B, C, D are just situations, but Roman 1 to 5 describes the conditions: war, hostilities, rebellion, commotion, disorder, munition of war, natural catastrophic such as earthquake. Although this what do you call this contiguous decision, I can't remember the English term. Now, although it doesn't fall into this category, these are almost equivalent to the categories described in Roman 1 to 4. So it says force majeure may include but is not limited to. So therefore, you can explain this clause to COVID situation also. Under these circumstances, I think this gentleman who has asked for compensation for COVID situations can be used the connected conditions of contract which is described here. I think there is another question by another gentleman. Shall I answer that before going into the chat? This is by, I don't have the name of the gentleman. Currently, I am working as a contract administrator on a bridge project. These days, we get a lot of claim notices from the contractor for the work delays due to lack of fuel, gas, etc. These claims could include cost plus EOT on continuing basis. In general, it's difficult for us to quantify and assess these claims without clear evidence. Any such suggestions? I think normally there is a type of contract where you say cost plus contracts. I think as this gentleman said, it's very difficult to evaluate. Now, the most important thing is actually when a contractor submits a claim, they must submit contemporaneous records. That means he must maintain records, regular records. Let's say if a workforce drops from 100 to 50, he must have a daily record of workforce. If he can't operate a machinery with lack of fuel, he must maintain those records. Whether those records are acceptable to the engineer or not, he must submit those reports to the engineer as well. So therefore, he must maintain contemporaneous records. Instead of cost plus contracts, we can say amount of loss incurred by the contractor and evaluate the actual loss incurred by the contractor. I think it is reasonable to pay him because it is not the fault of the contractor. So therefore, although you don't have to make a blanket payment to the contractor, if you can evaluate the items daily, regularly, you can evaluate the loss incurred by the contractor. You should be able, I think the contractor is entitled for such payment. But of course, if it comes to a situation where you can't proceed with work, you can terminate the contract under force majeure. Under force majeure, probably you might not have to pay a lot of compensation. You can terminate the contract under force majeure, where the event is making impossible to perform. There are other questions raised by the gentleman. I don't think I can answer because what I'm suggesting, Engineer Hemchandra, is next time, can they write this? Can you copy these questions and send to me so that it's easy for me to refer and answer?
Yeah, actually, as the operational rule when we are sending the flyer, we ask questions from them. We received only 3 questions. Next time, I think could you kindly? I'm asking all the participants. You can share your questions with us in advance so that our resource person can answer very precisely with examples and evidences. And on the other hand, when you are making your question, better you avoid maybe organization name as much as possible and frame them as a general question so that it is more comfortable for both parties. It's good for both parties. I think there are few questions, Dr. Anasinghe, there are few questions in the chat box. Maybe the next event we can take these questions.
How can you record these questions, or how can
I think it will be okay. I think we can record those questions. So again, I think I kindly ask the participant to send their questions in advance. We will send the flyer again next month event so that you can send the question to ISL and we can share the question with the resource person and we can have the fruitful discussion. So Dr. Anasinghe, then can we close the...
No, what I will do is next time,
Yeah.
I will explain about the conditions, few clauses in the conditions of contract also for about half an hour. In the balance half an hour also, I can answer the question. Now, I am working on a generator, but at the moment, actually, I don't have electricity. Please excuse me because we can have another session in a month's time.
Then thank you very much, Dr. Ranasinghe, for your time that you spent with us and your experience and knowledge that you shared with us. I'm thanking you on behalf of YESL and Association of Consulting Engineers and all the participants today. Thank you very much, sir.
Thank
And with
you.
that, good night to you all.
Good night. Thank you very much.